I'll start. Good afternoon, everyone. It is a great opportunity for you today as we have a guest lecture on practical aspects of maritime law for logistics students. So this is done as part of Setting Precedent by Business Law Society. And I would like to welcome Dr. Malika Gunasekera, who is a senior attorney at law and who is an expert on maritime law and law of the sea, who will share his valuable experience and knowledge with you today. So I would invite Rachel, who is Secretary of Business Law Society, to introduce and to move forward. Thank you.
Thank you, Nick. So, good afternoon, everyone. We are from the Business Law Society, and we want to apologize for the slight delay that we had issued. But we welcome you all to Setting Precedent, which is an interview series carried out by BLS with renowned lawyers from the industry, with Dr. Nick from the problem sector. So, for today's session, we have with us a very distinguished guest. He was the former dean at the Faculty of Humanities and Social Science, consultant dean, and dean of the Faculty of Management at the CINEC Maritime Campus. He is the appointed executive director of Ceylon Shipping Corporation Limited and director of Ceylon Shipping Lines, as well as the director at Ceylon Port Services. Moreover, he is an attorney at law and a consultant on legal affairs. So, without much further ado, I would like to welcome Dr. Malika Gunasekera to carry forward the Setting Precedent webinar. Over to you, Doctor.
Yeah, good afternoon. Can I know whether you can hear me?
Yes, sir, we can hear you.
Yeah, unfortunately, I don't know, my camera setting is not proper. It says no available camera found. So, but however, I will proceed with my lecture. So, good afternoon, everyone. Um, so today I have been asked to conduct this lecture on the practical aspects of maritime law for logistics students. And I have been also advised that most of the students are logistics, but in fact I have done this to CINEC students as well while I was a lecturer there, taking maritime law as a subject. So in this, I have done a very special presentation of mine based on the topic and to limit it for the 1.5 hours. So you all can now share the slides. So can go for the slideshow mode. Is everything ready?
Yes, sir. You can press it.
So you can go to the next slide. Now, let me first of all introduce how the maritime law apply to logistics area. Now, I know that you all already know what is logistics and what are the areas that fall under the subject of logistics. Therefore, I will straight away go to this question why maritime law is important for logistics. Now, you know that shipping is a main mode of transportation of goods in international trade. It is, especially for countries that are coastal states and also the countries that are connected to coastal states are more involved in carriage of goods by sea. So international trade consists mainly of the carriage of goods by sea. Over 98% of the world cargo are transported via shipping routes, and other carriage modes are used for 2% of the international trade, such as the air and land. And you know what is air transportation? Air transportation is quite expensive, and you can't transport goods by air with respect to every type of goods. So only very specific types of goods, especially like perishable items such as flowers or fish or something, they use the air mode. But even for fish now, they have the freezer containers. So fish are normally transported by sea. But for items such as fresh flowers, they use the air transportation. Therefore, less than even 2% are carried by air. And in other states that have the land connectivities, like the rail connectivity and road connectivity, they use land transportation for cross-border trade. But however, in a multimodal aspect, they use all kinds of transportation modes uh, uh, to transport the goods, and therefore land transportation such as rail transportation and road transportation can be used in such scenarios. And now you can see that because of that, over 98% of world cargo are transported by shipping goods. This is the reason that for logistics students, the maritime area is very important. The maritime transportation area is very important. Without the maritime transportation, you may not be able to affect your logistical things, because transportation is a vital element of logistics, and it is predominantly one of the biggest, the major areas involved in logistics. Logistics is not only the transportation, as you know, logistics involve many things, but predominantly transportation takes a big role or a major stage in the entire logistics area. So primary means of the distribution in logistics are involved with the transportation, as you know, because the primary means of distribution is a part of the logistics trade. And therefore, how do you have to perform the distribution in your logistics area? Then the transportation element comes into play. Well, so this is actually the connection between transportation and logistics. So, but transportation and logistics are two different subjects. But however, without transportation, logistics can't survive. You need to have the transportation element linked to the logistics. Now, where does the process of logistics start? As logistics students, you know that the process of logistics starts from the supply of raw material, right? Raw materials, and then it goes until the final production. But until from the final production also, thereafter, you need to do the transportation of the goods or the final production, not only the final production, even the transportation of raw materials, right? From the entire chain is connected to the transportation element, because you have to transport from the raw material stage up from, and thereafter the final production also have to be carried from the seller to the ultimate customer, the buyer, or the ultimate customer may be the supermarket or the store or whatever, the warehouse, or the final customer who is using that product. So in this case, even though the logistics start in the supply of raw materials, even in the raw material part you need transportation, and they are a part until the goods are delivered to the customer. The entire logistics chain operate, and transportation will come in not only in the transportation from the seller to the customer, but also in other sectors where whenever you need to effect transportation. Now there are several parties involved in the supply chain of goods. In that case, like for example, the raw material supplier starting with, then going into the factory, then from the factory to the hands of the seller, then from the seller to a ship, from the ship to the other side customers or the buyers port, then from there up to the hands of the customer through the warehouse, whatever, the entire supply chain is so connected, and logistics play the main role in this entire process of supply chain from the beginning until the end. So as logistics students and professionals, you're going to be one day in logistics field, you will experience in your profession that you need to apply these kinds of transportation solutions in order to play a role or act in the entire supply chain process. Now that is why transportation is important, and maritime transportation is a key area in the entire transportation chain. That is why we are learning today on the maritime aspects of logistics. Now, how does the initial contract for whatever the things, like for example to supply the raw materials, or from there onwards the finished good to be sold to the customer, or how the carriage matter to be done using a ship, all these things involve contract. So there are in a small thing there can be so many contracts. Now take for example, if we take Sri Lanka's tea exportation. Now in the tea sector, tea is cultivated in Kalawakeli. When it is cultivated and plucked, right? The tea goes to the blending, and from blending it may come to the port. So there has to be a kind of a contract for the transportation on inland transportation mode, like by way of a truck or by way of a train, right? So there is a contract for that transportation, right? From there onwards, when it comes to port, there will be a contract of carriage from that port to another port using the ship. And initially even the seller of the tea will be contracting with the buyer, right? What is called a sales contract. So there are then all these things involve small contracts. It is not maybe one contract, but it can involve several contracts. So we have to see, therefore, what is a contract? And that is the starting point. Now, in order to contract, first of all, there has to be an offer, where you offer the goods. You offer tea to a customer or to a buyer. So there has to be an offer. Either the seller makes an offer or the buyer makes an offer to the seller showing the intention of buying the tea. So there has to be an offer. The offer can be from the seller or the offer can be from the buyer. But whoever it is, the person who offers is called the offeror. Then on the other hand, there will be a person who accepts that offer, right? If the seller says, okay, I have a tea to be sold, then the seller is the offeror. Then the buyer says, okay, I'm going to buy it, then the acceptance is by the buyer. So the buyer becomes the offeree then. It can operate other way also, where the buyer tells the seller, I want to buy tea. Then the offer comes from the buyer, and then the seller says, okay, I will sell to you. Then the acceptance comes from the seller. So likewise, there are offerors and offerees, and the offeree is the person who accepts the offer of the offeror. Then in this process, nobody is going to give the goods for free, right? There has to be a consideration. Consideration in the sense something that can be valued and exchanged between the parties. Between the parties, parties are the offeror and the offeree, right? Then offeror, who is going to give the goods, right? He will say, okay, I am giving you the goods. Then you have to pay the price. So I give the goods, you pay the price, means that the consideration of both parties exchange between the both parties. So this is the consideration. The consideration has a value. The value is that for T, whatever the value that you are making, and the T is also on the other hand is valuable. So this is why we say there has to be a valuable consideration from both parties exchanging between the parties. So consideration is the third most important element in a contract. But what are the other elements that we said? Number one, there has to be an offer. Number two, there has to be an acceptance. Number three, there is a consideration. And thereafter, the fourth element is that there are obligations of the parties. The seller has certain obligations to the buyer. The buyer has certain obligations to the seller. Right? So which means that their obligations meet, and that those obligations are the one that gives legal binding on the parties. The buyer and the seller is legally bound by, because both parties oblige to themselves on certain things. So the fourth element in a contract is the meeting of obligations, which is binding the parties, legally binding of the party. Then thereafter, once the contract is so made, right, the parties will enter into terms and conditions, being ancillary part of contract. Like for example, how are you going to transport these goods from the seller to the buyer? Whether it is the seller who is going to transport, whether the buyer is going to take over the transport. So all these kinds of other ancillary things fall within the terms and conditions that the buyer and the seller are entering into. Next slide, please. So then in that case, what are the terms involved in carriage or transportation? When the seller and the buyer agree on the contract, thereafter they have to agree. Now, who takes the obligation to transport? Who take the obligation to insure the goods? Then who take the obligation to pay the custom duties at the exporting side or at the importing side? Right? And so likewise, who is going to do the documentary part of export, who is going to clear the imports, all these things the parties, the seller and the buyer have to agree between themselves. So in that case, in order to facilitate that, there are certain in-court terms that can be used, the international commercial terms that are created by the ICC or the International Chamber of Commerce. Now, in-court terms are not laws. Some people think that in-court terms are laws. No, in-court terms are really, in-court terms are really for the convenience of the parties, for them to understand what are their mutual obligation towards the other. They agree on a in-court term, right? Normally, one in-court term in a contract, not several in-court terms. So they can decide what kind of in-court term they are going to enter in the terms and conditions of the contract. Now, there are in-court, there are at the moment under the 2020 version, there are about 11 in-court terms that the parties can make use of. And when you look at those in-court terms, there are simply Incoterms that can only be used in the sea mode of transportation. And there are also Incoterms that can be used in any kind of transportation involving sea or not sea. So I can divide the Incoterms, especially applicable to shipping, which are like FAS, free alongside ship, right? Then you insert the name of port of loading. Then free on board, insert, they are also like that. Then CFR, CIF. So these are 4 Incoterms that are very specifically applicable to sea mode of transportation. Now today, my duty is not to explain to you all on the Incoterms, because I think some other lecture will elaborate you all on these Incoterms, but I want to show you that about why we are using these Incoterms is as a part of the sales contract, that when it comes to delivery of the goods, like I told you, who will take the burden of transportation, who will take the burden of insuring, who will take the burden of paying the cost. Likewise, so whenever you choose a particular Incoterm, that will that will define the shipper or the consignee, or the buyer or the seller or the buyer, of their own respective duties under the Incoterm that they have used. So this is not law. This is for the convenience of the parties that they decide. Then there are Incoterms that can also be used in shipping, where multimodal transport is involved. So whenever other types of transportation are involved. The first one is ex works, then the free carrier, then carriage paid to, carriage and insurance paid to, then delivered at place unloaded, delivered duty paid. So all these things are other types of Incoterms that you can use where your transportation involves multimodal transportation elements, right? So what are the types of carriage by sea contracts? Now, especially when you select a sea carriage, or where your carriage has to involve sea. Now, in Sri Lanka, we know we are an island nation. So obviously international trade either has to take means of sea carriage or air carriage, right? Because we can't go on land carriage means when it comes to international trade. So now my lecture is based on the sea carriage. Right? So whenever there is a sea carriage, you have to have a contract to carry the goods by sea. Right? Now there are 3 main types of contracts that can be done in a sea carriage. Number 1 is charter party. Charter party is where the charterer comes into the picture, that the charterer undertakes to carry the goods of the shipper or the consignee, whoever who has the duty to take the transportation element as per the Incoterm that they use, right? And thereafter they have to look now for the person who can charter and bring the goods to the destination of the buyer, or what we call the consignee. So there are mainly 3 types of charter parties involved in the shipping trade. Number 1 charter party is voyage charter. Now in a voyage charter, you don't see a charterer per se. There is no specific charterer in a voyage charter party. Voyage charter parties are used in liner trade. What we call, you may know what is liner trade, like there are certain shipping lines like Maersk, Costco lines and like that. What they do is, they take over your goods and transport it to the destination that you want the goods to be transported. So now if you take Maersk line will take over your container. Mainly the container carriage is used in voyage charter party. So for the space that is needed to carry your container, the liner will give you a space for that. Nowadays space is called CMB, or cubic meter wise. Cubic meter. Cubic meter is, you know how to calculate cubic meter, that is length multiplied by length multiplied by width multiplied by height. Usa වැඩි කිරීම, දිග වැඩි කිරීම, පළල. That's how you come to a cubic meter. So on cubic meter basis, the ship or the carrier or the liner will decide on the freight rate that you have to pay for that particular voyage that the charterer will perform. The voyage, say, from Colombo to New York. Then from Colombo to New York, how much you have to pay for the container. This is called voyage charter party. And in the voyage charter party, you are only given the space for your container, right? The space for your container. Then the second one is time charter party. Now, in a time charter party, it is actually a charterer comes into the picture. What happens in that is that a particular person charters a ship or a vessel from a ship owner, and he runs the ship for a particular time period that they agreed by the time charter party. Charter party is a contract, right? So during that time, the charterer runs the ship, but normally he is not coming on board the ship. It is the ship owner's crew will take the ship, but the charterer is the contractual party with the cargo owner who will take over the goods and deliver to your doorstep, or the port or whatever. So it is for a particular time period. Normally time charter party is used for bulk cargo situation. It is not used for container type cargoes unless the entire ship consisting of containers. So I was talking about this charter party, and then I explained to you about the voyage charter party, time charter party. Isn't that so?
Yes.
Right. So now I told you that the time charter party is where the charterer enters into a particular time period to charter the vessel or the ship, and during that time he is using to transport the goods. Normally it's not for container type but for bulk type of shipments that they do a charter party. So then in that charter party the cargo owner enters into the contract with the time charterer to take his goods to the destination of the customer or the buyer. Then the third category of charter party is called bareboat or demise charter party. Both names are same with respect to that particular type of charter party. Now what happens in a bareboat or demise charter party is that the charterer takes over the entire ship and the control as if he's the owner. So he enters into a charter party contract with the owner of the ship to charter the ship to run by himself. Then the charterer runs the ship, and whatever the goods that he wants to carry, he can carry and deliver to the customers, right? So these charter parties are one type of contracts that are used in shipping, right? Then the other type of contract is called the contract of affreightment. Contract of affreightment is where you have a huge bulk cargo that cannot be carried in one ship. So you have to hire several ships for the carriage. Now take for example the coal transportation to Sri Lanka. Our Norachole thermal power plant is run by coal. So we need a huge quantity of coal to be carried. During say 6 months time, we have to carry about 2.2 million metric tons of coal. Now in that case, you have to use about say 30 to 40 ships to bring that coal to Sri Lanka. So what you have to then enter is a contract of affreightment, because you have to have number of ships carrying this cargo. So for that such a thing, you have to enter into a contract of affreightment with the carrier who is going to carry your goods. Now the third area of a sea-related contract, sea carriage contract, is a bill of lading. But of course, bill of lading is not a contract itself, right? Bill of lading is not a contract itself. But whenever there is no other communications or other kind of collateral agreements between the carrier and the cargo owner, bill of lading can be considered a contract. But however, in law, bill of lading is only an evidence of a contract. It is only an evidence of a contract to show that having a bill of lading is that there has been a contract of carriage. So bill of lading is only an evidence to show that. But bill of lading has three other characteristics. It is a title document. It is a title document, which means that whoever who holds the bill of lading will have the title to the goods that correspond to that bill of lading. So it is a title document. Then also the bill of lading can be considered a receipt. Receipt that the goods have been loaded on the vessel or the ship. And the other element, the last element, is that it is a document transferring the constructive possession to the goods. Because, when you give the goods to the ship will have the actual possession of the goods. What you get is a bill of lading, which is a paper. By paper, you are having the title to the goods, but you are not having the control of the goods. The control of the goods remain with the ship owner or the carrier. So therefore, what you get from a bill of lading is a constructive possession to the goods, because being the holder of the bill of lading, then you can say that you are the rightful claimant for the cargo, right? So that's why the bill of lading has these characteristics, but bill of lading is not a contract, it's only an evidence of a contract in first place. Unless you have no other kind of communication or collateral agreements, then of course bill of lading can be considered a contract. Now, what are the laws applicable to contracts of carriage by sea? Now we are coming into the legal side. What are the laws that are applicable? Now, internationally, there are international rules, like the Hague Rules of 1994, that is applicable to bills of ladings, where the carriage consists a bill of lading has been issued with respect to a carriage, then Hague Rules can apply. Then Hague Rules 1968, then the Hamburg Rules 1978. All these three conventions are applicable and enforced. And then look at the Rotterdam Rules 2008, which is not enforced. And the Multimodal Convention 1980 is not enforced. Anyway, the Multimodal Convention 1980 will not come into force because it is now dead. But Rotterdam Rules is still live, but it is not enforced. It might go into a natural death because most of the countries are not willing to become parties of the Rotterdam Rules. So what are the applicable international rules that are prevailing right now? Are the Hague Rules of 1924, Hague Rules of 1968, and Hamburg Rules of 1978. Now, several different countries are party to these rules. Sri Lanka is only a party to the Hague Rules of 1968. So therefore, in Sri Lanka, we apply the Hague Rules, and we apply the Hague Rules under our law of Sri Lanka, which is the Carriage of Goods by Sea Act, number 21 of 1982. So Carriage of Goods by Sea kina panata තමයි අපේ බලාත්මක නීතිය with respect to carriage of goods by sea. So whatever the issues, the disputes arising out of a carriage of goods by sea in Sri Lanka, or where Sri Lankan parties are concerned, if they have consented to the application of that rules, international rules, then the applicable rule in our country, in our law, before our law, if there is a dispute or issue before our law, then the applicable law is the Carriage of Goods by Sea Act, number 21 of 1982, with respect to the sea carriage area. Next slide, please. So for the purpose of logistics students, I will say that for the air carriage also there is a local law which is called the Carriage of Goods by Air. There is a new act, I think in 2018 or so. Right? Then, with regard to the shipping area, conditions of ships and shipping is a very important area, because if you are going to transport your goods using ships, right? Then you have to know the main important elements involved in the shipping side. First and foremost, every ship must be seaworthy, right? Every ship must be seaworthy. Now, what is the seaworthiness of a ship? That means when the ship commences its voyage from one port, it has to be seaworthy. Otherwise, the ship can't go. If the ship is not seaworthy, the ship can't go. In Sinhala, we say, Muhudu Yogyatavya. Muhudu Yogyatavya. Now, we know in our vehicles, we need to get the Dumsahatike. Why do we need to get the Dumsahatike? Especially to say that our vehicle is roadworthy to travel on the road. So we need to have the roadworthiness in that. So likewise, for a ship to go in the sea, the ship must be seaworthy. So now it is actually a warranty that the ship owner has to give at the commencement of the voyage. At the commencement of the voyage, the ship has to give to be seaworthy. Otherwise, if the ship is not seaworthy, it is not suitable to go at sea. Now, this is something that even I took during the Express Pearl incident. Some who have followed the Express Pearl incident may know that I appeared in the TV and I said the Express Pearl ship, when it came to Sri Lanka, it was not seaworthy because the ship, when it left the last port, which was the Indian port, Hazira or something, at that moment there was a leaking container. So therefore, the ship was not seaworthy. That was my argument. So if the ship is not seaworthy, then it is not suitable to go to the sea, right? So this is a warranty that the ship owner must give, that his ship is seaworthy at the commencement of the voyage. Now, if something happens in the middle of the sea, suppose that seaworthiness was there at the commencement, but something went wrong in the middle of the sea, then we don't say that the ship is not seaworthy. What we say is then the ship has met with the peril of the sea. The ship has met with the peril of the sea. So, in order to fulfill the seaworthiness of a ship, the ship owner is required to employ due diligence, right? Due diligence to make that his ship is seaworthy, then his ship is technically worthy. That ship seaworthiness means that the ship can make the voyage from Colombo to New York, the voyage can be done. Then technically worthy means that the ship has all the equipments, everything, the engines are in order, all these things. So therefore the ship is technically worthy. And also that the ship is purpose worthy. That to carry the cargo, it is perfectly okay. Now the Express Pearl situation where I argued is that it was not purpose worthy because there was a leaky container. So if there was a leaky container, then the ship was not seaworthy. Right? So this is what you say. If it is a cruise vessel, it has to be seaworthy for the people. Purpose-worthy. Purpose is to carry the people. If it is carrying goods, it has to be purpose-worthy, the goods for the purpose of carrying the goods. If it is for like a gas ship, the ship that takes gas, then it has to be purpose-worthy to carry that gas. So seaworthiness has three elements. It has to be voyage worthy, it has to be technically worthy, and it has to be purpose worthy. So if the ship owner must make sure that he employs due diligence in making sure that the ship fulfill all these three elements. Now ship owner doesn't do all these things. It is actually a classification society is doing. That is why you say that the ship is class, right? Class. Unseaworthiness of the ship namely threats the maritime environment And we know what happened in the Express Pearl incident. When the ship was unseaworthy, how it damaged the maritime environment of Sri Lanka. And now in the operation of the ship, the nationality is number one, nationality of a ship. Now every ship must have a nationality. Now how do you define that nationality? Normally when a ship is made or created, right, at that moment the owner of the ship must, when the ship is ready to sail, the owner must apply for a registration in any country, right? If it is a Sri Lankan owner, either Sri Lanka he can make the registration application, or he can make some other country, right? Whatever. But however, a ship must be registered. Every ship must be registered in a country. So whenever there is a ship registered in a country, that country will give a flag to that ship to fly. So the ship is then flagged. If it is registered in Sri Lanka, it is entitled to fly the flag of Sri Lanka. Right? Now also there are possibilities that the ship can have a dual or multiple registration. Now we know that there are some people who have dual citizenship, right? Sri Lankan citizenship and American citizenship, dual citizenship. So that is possible. So likewise, even a ship can be registered in two countries. If it is registered in two countries, it is called a dual registration. It can be more than two countries, then it's called multiple registration. But however, in every case, the ship will be entitled for the flag of those countries that the ship is registered under dual or multiple. But at any time, ship can fly only one state flag, one country flag, not more than one, not two or three. Only one state flag, the ship can have the flag. If the ship wants to change the flag, it has to be done at a certain port in a country. Then only you get the permission from the harbour master, and then you change the flag of that ship. Now, why do you want to have different types of flags or registration? Because there can be advantages like economic advantages, for tax reasons, or for other national security reasons. Sometimes, now just imagine if an American vessel, ship, going with American flag to North Korea, will it be able to go? No way, right? So because of that, they might ask for a flag that is more friendly with North Korea, right? Maybe Sri Lankan flag. Then with the Sri Lankan flag, they can go to the North Korea. So now suppose that an American vessel or a ship coming to South Korean port, and from there they have to go to North Korean port. Then they know they can't go with the American flag. So what they do is, in South Korean port, they change the flag to a friendly state and then go to the North Korean port. Then North Korea can't do that. Maybe they know that this is American, but doesn't matter, because the nationality with the flag that it is flying rested with the ship, right? So flagging is very important. It's for convenience and it's for opportunities also, like tax opportunities or some other regulations and deregulations, you know. Then ships are controlled, standardized and certified, right? And how do you control ships? There are three types of controls. Flag state control. The country that gives the flag to a ship controls that ship. For every respect, that flag state will control that ship. Then port state control. Whenever a ship enters into a port, that port will have control over that ship. That is called the port state control. Then coastal state control is where a ship is outside the port, but within the coastal area of a country, then that country has the coastal state control over that ship. Now just imagine, for example, Sri Lanka has a port area. Colombo port is about spreading for about 9 kilometers from the port. So that is called the port area. Now express power situation happened within the port area, right? But now Sri Lanka has a 12 nautical mile territorial sea. Territorial sea is like the land. It belongs to the land area, but it is a different functional zone. It is the sovereign zone for the country. Within that zone of territorial sea, we can apply the same laws as our land. But beyond 12 nautical miles, then we have the exclusive economic zone running up to 200 nautical miles from the baseline or from the coastline. And within that 200 nautical mile zone, after the territorial sea, we don't have sovereign rights, we only have controlling powers that the ships can't engage in fishing and natural resource exploitation. Like when something happened in that MV New Diamond incident. In the New Diamond incident, Sri Lanka then have a coastal state control in that situation because it happened within the exclusive economic zone of our country. So that the country has a coastal state control. So ships are under these three main types of controls. Flag state control, that is their own flag is controlling their vessel or the ship. Then port state control, where the port controls the vessel or the ship when it comes there. Then the coastal state control, as I told you, within the coastal state areas, the coastal state controllers have the particular power to control that vessel. Like for example, the Sri Lankan Navy can look into any kind of threats to the Sri Lankan coast from a vessel. Then Sri Lankan coast guards can look in coastal state control if there is kind of immigration law violation, like for example if refugees are coming to our country, then the coastal guards can control such a vessel. Then for marine pollution, the Marine Environment Protection Authority (MIPA) can do the coastal state control with regard to pollution incident. The International Maritime Organization, which is the watchdog of shipping, the IMO is the main organization under the United Nations, specialized organization that is attending IMO. It creates a lot of laws, regulations, recommendations, directives and so forth for the observations of the proper shipping matters and conventions and protocols it has created. So it maintains a proper check on the ships, how they are conducted worldwide in the shipping. Then next one is the competence of the crew is a very important element, because the crew has to be properly certified, with proper knowledge and experience to handle the matters, and they have to be certified and like under the STCW convention, the convention on the safety certification, crew competence, all these things are covered under the STCW convention, and they are under that the crew have to be competent to handle the ships. So these are very important things, that ships are so controlled also with regard to the crew, the people who are operating the ships. Next slide, please. Right, now I come to the area of carriage of goods by sea, because that is very, very specifically applied to your area of logistics, right? So now when you, like for example, think about a situation that you have given some goods on board a ship. On what basis the carrier has to perform the duties? When you give certain goods on board, then number one is the carrier has to perform his duties according to the contract of carriage. Contract of carriage is between the carrier who carries. Carrier can be ship owner, carrier can be charterer, as I told you before. So the carrier has to do the carriage obligation under the contract of carriage, and the other party in the contract of carriage will be either the shipper or the consignee, what we commonly say cargo owner. So the contract of carriage is between the carrier and the cargo owner. So the carrier has to perform his duties as per the contract of carriage. whatever the terms and everything that they have agreed between the parties, the carrier has to conduct himself as per the contract of carriage. If there is a bill of lading issued, then the bill of lading is also governing the carriage contract, the carriage obligation. So you have to go according to the bill of lading as well. Bill of lading terms and conditions, normally generally written or printed on the other side of the bill of lading. So as per the bill of lading also, the carrier has to perform the duty. Does the shipper consignee has any duties? Now we don't discuss about a carrier. Yes. Does the shipper or the consignee has any duties? Of course. The shipper must provide accurate information with regard to the goods. So this is something that if you go into the shipping trade one day, you will see that all your documents, everything has to be accurately given to the carrier. Because otherwise you will find fault by the carrier for not providing accurate information. Shipper must provide accurate information. Then consignee, on the other hand, to be bound according to contract with the passing of titles of the goods. Say for example, when the goods arrive at the port of destination, we say the receiving port, unloading port, the consignee must present the proper documents in order to obtain the goods to him, right? So these things the consignee is bound to do according to the contract, and then obtaining the goods to his title, or he attaches the title to the goods by presenting the documents. So this is very much documentary trade area shipping. So in what circumstances the cause of action of cargo owner may arise? Now whenever there is a problem, dispute with regard to your cargo, right? Now, what are the types of actions that are available? Now, number one is based on breach of contract. On the breach of contract area, if your goods are wrongfully delivered by the ship owner or the carrier, then you can say it's a breach of contract and therefore you have a claim against the carrier. If the goods are short delivered, say for example, your goods were 50,000 metric tons, but finally you received only 45,000 metric tons. 5,000 metric ton loss. Then you can, for short delivery, you can make a claim against the carrier and breach of contract, under breach of contract. Then misdelivery. If the carrier has given the goods not to you but to somebody else, so it's a misdelivery. It can be also wrongful delivery, but there are differences between wrongful delivery and misdelivery. Then if your cargo got lost or damaged, then in that case you can claim against the carrier based on the breach of contract. Or if there was a deviation, say the journey was from New York to Colombo today, suppose that the ship has gone to London and come, so then there's a deviation. So the pre-agreed journey the ship has to do. If there is any deviation, the ship owner or the carrier is liable. The deviation is only allowed on two grounds. That is called justifiable deviation. Justifiable deviation is only allowed on two grounds. And what are those two grounds? Number one, if the ship deviated for the purpose of saving another life at sea, either in another ship or whatever, sea or whatever. If that ship has deviated for the saving of a life, then that is a justifiable deviation. The second one is if the ship has deviated for the save of cargo in another ship, right? When the other ship was at distress, this ship has gone in order to save the cargo, then in that case, this ship's deviation is justified. So only in those two deviations, justifiable deviation. Number one, to save life. Number two, to save cargo. Only deviation is allowed. So these kinds of things can be found in breach of contract. These things can be found also in tort law, under tort, civil wrong. Tort is called a civil wrong. Now if somebody injures you, say somebody hit you and injures you, then that person is committing a civil wrong against you. Then that is called a tort. you have incurred injury, right? You have sustained injury. That is called tort. So, not based on the contract, but for the damage or loss that occurred to you, you can claim on tort. And what are they? The same thing, like wrongful delivery, short delivery, misdelivery, damage or loss to cargo, deviation, and maybe I left F blank is to show that there can be more types of things. So that can be addressed under tort law also. So action can be filed under breach of contract or action can be filed under law of tort. You have the liberty. But if you are filing under contract, breach of contract, you have to show very carefully and correctly that there was a breach in the contractual term, in the contract of carriage, that had resulted in this either wrongful delivery, short delivery, misdelivery, damage or loss or deviation or whatever. Now, in what circumstances that cause of action? Cause of action क्या कहना भी कहना नाडु निमित्त कहने का, right? नाडु निमित्त they arise for carrier against cargo. The මොනවද අවස්ථාවකද? carrier ට පුළුවන් වෙන්නේ नाडु निमित्त හටගත්තොත් cargo owner ට විරුද්ධව. Right? Especially if there is a misstatement in the document like bill of lading or contract of carriage that the shipper has given misstatement in that document. Then the carrier has a cause of action against cargo owner. Misrepresentation or misrepresenting the parties or the goods or whatever. If the shipper has misrepresented the facts, then in that case there's a claim for the carrier against the cargo owner. Thirdly is called the general average. General average is where the ship owner has saved certain part of cargo at the expense of another part of cargo. Then the cargo that has been saved, the cargo owners have to pay for the cargo that was destroyed or put out of the ship in order to save your cargo. So general average is a big concept. I can't lecture about general average in this small time, but general average is something that a carrier may have against the cargo owner. General average claim, it's another big topic to discuss. So if I'm given the opportunity to discuss about general average, I can do that, but not today. Next slide, please. I think I'm going to the last slide. That's about dispute resolution. Now, if you have a dispute in the carriage of goods, especially using the sea mode, the ships, then what types of actions that are available in dispute resolution? For say for example, a cargo loss or damage. So what type of dispute resolution? You have actions against the carrier, right? So on the carrier, if your goods are damaged by the carrier, you can sue the carrier. Carrier can be ship owner, carrier can be the charterer, whoever, right? Now, if the carrier has a case against you that you have provided wrong information and because of that he ran into an issue and he sustained damage or loss, then there can be actions against the shipper or the cargo owner in such a situation. Now, what are the different modes of dispute resolutions available? What are the different modes? So, there can be criminal actions. Suppose that a party in the shipping area has committed a criminal act within your, some criminal act has taken place. So there can be, in shipping, there can be criminal acts. Suppose that your goods have been intentionally, purposely damaged. So if that case, like for example, the criminal act of mischief, අපි කියන අනර්ථයක් සිදු කළා කියලා සිංහලෙන් අනර්ථයක් සිදු කළා. ඔයගොල්ලන්ගේ භාණ්ඩවලට අනර්ථයක් සිදු කරා නම් ship owner එනම් ඒක criminal act එකක්, right? So there can be criminal act. Then there can be civil actions. Civil actions can be against the carrier. Civil actions can be against the contractual carrier. Civil action කියලා කියන්නේ like if you are going to sue the carrier in the civil court of law. like a district court, for example, you're going to ask for compensation and damage in a civil action, right? Then there is also a very specific class of actions in shipping called admiralty actions. Admiralty actions. Admiralty Nadukara කියලා කියනවා. But as admiralty actions are against the carrier mainly, the ship, charter, the ship or the carrier. If you have a claim against the ship, then you have to file the action against the carrier or the ship. Carrier in personam වල ship එන්නේ in rem කියලා. ඒ මම පස්සේ ඒක උගන්වනවා මොකක්ද කියන එක මේකෙම තියෙනවා. Right? Admiralty action. Then if you don't want to go into kind of litigation in court, then you have alternate dispute resolutions. What are them? Negotiations. Right? You can go for mediation. You can go for arbitration, like settling modes, means of mutual settlement. You can go for negotiations, mediation, or much higher is the arbitration. Now, what are the admiralty actions as per Admiralty Jurisdiction Act number 41 of 1983? There is a Sri Lankan law pertaining to Admiralty Jurisdiction Act called number 441 of 1983. Now, according to Admiralty Jurisdiction Act, whenever you have a claim against the ship or the ship owner, you can have these two types. Actually, if you are going to file a case against the ship or the vessel, then you have to file an action in rem. Action in rem. Now, by the make a Latin term. This is Latin term. Rem means res. Res කියලා කියන්නේ Latin වලින් property. That means you are filing the case against the property. What is the property? Property is the ship. So your action is against the ship. Action in rem, where the ship or the vessel can be arrested in that claim. අපිට අත්අඩංගුවට ගන්න පුළුවන් මේ වගේ අවස්ථාවකදී මේ ship එක or vessel එක. Action in rem එකකදී. The other type is actions against the carrier or the ship owner personally. ඒගොල්ලන් company එකක් වෙන්න පුළුවන්, ඒගොල්ලන් ස්වාභාවික පුද්ගලෙක් වෙන්න පුළුවන්. මේ අපි වගේ whatever, you can have the action against that person. So it is called action in personam. That is also personam is a Latin term. So actions in personam, right, can be done. In that case, you can ask for a Mareva injunction. What is a Mareva injunction? That means if you file the case against the person who is responsible, like the ship owner or the carrier, then you can ask the court to issue a kind of injunction or a ceasing order against the property of the ship owner or the carrier. But that property must rest in that particular country for the court to give such an order. Right? So we don't see much of in-personal matters because of that difficulty, because ship owners have their properties in other countries, right? So, but we have more actions in rem, where we file against the ship and at the same time we ask for the ship arrest from the court. Then lastly, in what circumstance can the parties go into arbitration? Arbitration has become a very popular mode. මේකට කියන අපි බේරුම් කරන්නේ නැත්නම් බේරුම් කරන ක්‍රමය කියලා. This is arbitration is a very popular mode nowadays, but arbitration can only be sought if there is an arbitration clause in the contract of carriage. If you have an arbitration clause, then definitely you can't go to court, you can't go for litigation, you have to go to arbitration, compulsory arbitration. So normally in contracts of carriage and bills of ladings, they put an arbitration clause, but sometimes they don't put any arbitration clause. So if you want to go into arbitration, or if you have to go to arbitration, then there has to be an arbitration clause in the contract of carriage or in the bill of lading. Otherwise, if there is no arbitration clause in the contract, the parties can mutually agree by special agreement to refer this matter for arbitration. In that case, when the parties in the dispute, claimant and the respondent, like shipper and the carrier, they agree on an arbitration, they can enter into a special agreement, specially entered for the arbitration, and then go into arbitration based on the special agreement. So likewise, they can to the arbitration process. We can go to the next slide. So I think thank you very much for listening to my presentation. We got late, we got interrupted, but I believe that now you all have understood the area. If there are any questions, you can pose to me.
Yes, thank you so much, Dr. Dan, for this very informative lecture. And I'm sure all the students here would have benefited greatly from the knowledge that you shared with us today. And I would like to specially thank you, sir, on behalf of the Business Law Society for taking time off your busy schedule to be with us this evening and making this webinar such a wonderful success. And we wish you all the success for your future endeavors. And once again, thank you for being with us here, being with us today. And
Thanks
I
so
would
much.
also like to thank everyone.
Yeah, thank you very much for inviting me the NSBM Green Campus, and also Ms. Setiarachi for giving the introduction, and also Samitri for inviting me. I'm very I mean, I'm always available if you want me to do a lecture on these things, because it's actually a kind of a part of my hobby right now. Because now I don't do lectures to universities on a regular basis. I'm more into practice in the legal field. I'm a legal practitioner, so I don't have time to give regular lectures nowadays. But I do lectures till Columbia University Faculty of Economics and Department of Economics in the shipping area, Faculty of Law, and CINEC and other universities if they invite, and also training for corporate sectors. But what I want to tell is that I saw during my presentation that at the beginning there were more students. Then maybe because of the electricity failures, some students have to they have to go. So you can share my presentation online, no problem. YouTube or whatever you can do. I give the authority, so no problem. You can. So for the benefit of all the students, things can be shared, and also including my presentation that I have shared with Sanitri, that can be also shared together. Thank you very much for inviting me again.
Thank you so much, Dr. Dan, and thank you for giving us the permission to share this lecture online. And thank you everyone else for joining with us today. Your presence is really appreciated, and I hope this webinar was useful for the understanding of maritime law that's related to your subject. And if you want to rewatch this session and take down more knowledge and detail, it will be uploaded to the Business Law Society of NSBM YouTube channel. And that brings us to the end of setting precedent, the webinar series. And thank you all for joining, and have a pleasant evening.